All right, everyone. Welcome back to the conference. My name is Paul Saphir at the law firm Ballard Spahr, and I'll be moderating today's second panel, which, as Sandy mentions, focuses on regulating political advertising online. Before I introduce the topic in more depth, I want to introduce our panelists. So we have from NYU, Professor Rick Pildes. Did I get that right?
Yes, you did. Very good.
Rick Pildes, he is the Sudler Family Professor of Constitutional Law at NYU Law School, where he focuses, among other things, on the intersection of the First Amendment and election law. We also have Dan Weiner, who is the Deputy Director for the Election Reform Program at the Brenner Center for Justice, where he has been heavily involved with some of the legislation efforts that we will discuss in today's panel. And our third panelist is Alan Dickerson. He is the legal director for the Institute for Free Speech, an organization that focuses on specifically on, or most centrally on, political speech. And he was also, I learned in planning the panel, Rick's student in legislation, right?
Yes, years ago.
And has, from what I understand, has no grudges against them that will work their way out today. So
not at all. It was a privilege.
Excellent.
He was a great student.
There we go. So the specific focus of this panel is on regulating political advertising online, and specifically a number of attempts in the states and also in Congress to expand the regime of campaign finance law to address what was perceived as some of the problems of the 2016 election. So to beef up the regulatory regime as it applies to digital political advertising in response to concerns about manipulation of the electoral system in the 2016 election, including by foreign actors. To sort of connect this panel to the previous panel, in terms of categories, political advertising is difficult to situate, right? On the one hand, it's political speech, so it lies at the very core of the First Amendment, as Dean Post explained in the first panel. And you know, if you think about it, New York Times v. Sullivan was an advertising case, but it was analyzed as a defamation case and not a commercial speech or false advertising case. On the other hand, political advertising is advertising. And so it raises the sort of regulatory concerns that Genevieve talked about, where you have unequal power relations and some expectation that we might want to do things as a society from a regulatory perspective to sort of deal with that unequal power balance, that, you know, it's not ordinary unpaid political speech, which we will leave on its own completely, but it's a form of potentially manipulative political speech that you might want to intervene with respect to and increase the level of information provided. Sort of the third thing that's unique about political advertising is the extent that it's appropriate to think of it as, you know, voting as consumerist behavior. It's nonetheless extremely important consumerist behavior. It's not, voting is not just selecting what kind of toothpaste you're going to purchase. It is extremely important, and that sort of cuts both ways from a regulatory perspective. On the one hand, it suggests that we as a society have a huge stake in getting it right and having accurate information out there. And on the other hand, it arguably is sort of so important for the maintenance of our society that there are concerns about the government intervening. So that sort of said broadly, the kind of laws that we're talking about, the sort of newly enacted laws to regulate political advertising online, what's sort of new and unique about them and potentially raises new First Amendment issues is that they don't just regulate purchasers of political ads. They don't just say, if you're going to place a political ad on a website or on a digital newspaper, you have to disclose who you are. But they also, at least in some instances, have imposed regulations on the platforms themselves, on the newspaper, on Facebook, on Google. And that's what's sort of new and unique about them. So what I'm going to do in a second is turn things over to Dan, who will talk about these laws in more detail, where they come from, what their purposes are thought to be, and how, if at all, they sort of change the existing campaign finance regulatory regime. Then once he does that, I'm going to talk a little bit about the one case which I was involved in which these laws have been litigated, which is the Washington Post v. Mcmanis case that was recently decided by the Fourth Circuit. So I will now turn things over to Dan. Oh, you're muted.
I love Zoom. This is so much fun. All of us are having fun. So it's a pleasure to be here. And I was not Rick's student, although I was a student of several of Rick's students. So it's a privilege for me as well. And to be in the panel with all of you. Alan and I have been in the same field for a number of years, and it's always fun. And Paul, you and I were on opposite sides, although in a very interesting case that we're going to talk about today. But I thought I would start off. I'm going to talk a little bit about the legislation, but I think it's important to acknowledge with this panel that we're coming here to talk about these issues at a pretty extraordinary time. Obviously, this conversation is happening, for one, in the shadow of a remarkable confrontation between the President of the United States and one of the major platforms that resulted in an executive order around Section 230 of the Communications Decency Act that might come up today. So that is something that I think most of the attendees here are probably very aware of and thinking about. But, perhaps even more important, everyone here is surely aware that we're sitting here talking about these issues in the midst of a nationwide wave of anger sparked by the brutal killing of a Black man in Minneapolis, my hometown. This is sadly not the first of these incidents. And what we know is that in the past, foreign adversaries of the United States have exploited similar feelings in the wake of the Freddie Gray murder, in the wake of other killings, for their own ends. This is really their MO. They take legitimate and profound grievances over injustice in the United States, and they turn them, and one of the things they do is they turn them towards campaigns of disinformation that actually seek to disenfranchise and disempower some of the communities and really the principal community most affected by these incidents, African Americans. And we saw that in 2016, one of the goals of Russia's disinformation campaign was to drive down turnout amongst Black Americans. We're already seeing disinformation efforts happening again around these issues. So the stakes here around the new protests from state actors and otherwise. So the stakes here are very high. And then if you add to that, of course, also the significant disinformation that is already on the loose around the COVID-19 pandemic, from domestic actors, but also from state actors. And I can tell you that I have virtually no doubt that in due course, that disinformation will be turned towards the election. To drive down turnout and sharpen American social divisions. This conversation is a little academic and it's a little abstract, but it's also the very, very real consequences right now. And they're consequences that probably demand humility from all of us on all sides. Obviously, these are not new issues. In 2016, the Russian government's interference in the presidential election was called by Special Counsel Robert Mueller sweeping and systematic, and focused in significant part over disinformation campaigns around social media. Paid political ads, while they were not the sole, instrumentality for that disinformation campaign, did play a significant role. We estimate that the Kremlin spent, in the neighborhood of $400,000 or $500,000 on these ads, which may seem like not a lot, but they reached tens of millions of people. In addition, I think it's important to understand that in context, paid political communications that were deployed in 2016 and that are being deployed now were frequently used in concert with unpaid communications. They were used to test out messages. They were used to get followers for specific pages that could then be, the recipient that sent out unpaid messages. And of course, they were targeted and sometimes micro-targeted towards strategic communities. So it's much more effective, and this is something you can do most effectively over the internet if you want to send, your political communication to white men in northeastern Pennsylvania who shop at Walmart or something like that, or similar communications. And it was extraordinarily effective, and it was used by domestic actors, and it was used by non-domestic actors. And the goals were not just to advocate for candidates, but also to sow social discord and in many cases drive down voter turnout. At the same time, intelligence officials, I think almost uniformly have suggested that 2016 was just a dry run for 2020. We're already seeing more sophisticated tactics, and we're seeing tactics that mimic much more effectively sort of traditional American political communications. So the sorts of ads that we know state actors are placing now look much more like the political ads you might see from a campaign or you might see from an American source than before. They're coming much better at mimicking domestic American politics, but again, for their own ends. So quickly, what are the regulatory approaches that have been taken? The most notable, and the one that I was going to run through briefly with you today, is a bill that has been passed several times by the House of Representatives at the federal level called the Honest Ads Act. And it's a bipartisan bill that was drafted by Senator Amy Klobuchar, Senator Mark Warner, and originally Senator McCain, Lindsey Graham, moderate Republican, is now one of the co-sponsors. He replaced Senator McCain after he passed away. And the Honest Ads Act really does, it does a number of things, but I'm going to sort of briefly summarize the four key provisions from my mind. One of them is that it extends the definition under federal campaign finance law of what we call an electioneering communication, otherwise known as a sham issue ad, which is an ad that mentions a candidate within a pre-election window and under the presidential level targets that candidate's jurisdiction, congressional district, state. Traditionally under BICRA, the McCain-Feingold law, the only media covered under the electioneering communication provisions were broadcast, cable, and satellite. The Honest Ads Act extends that to internet, paid internet ads. But it's, one of the key things, though, is that it leaves in place the spending threshold, which is relatively high, $10,000. And as we know, the spending threshold for these things, $10,000 will buy you a lot of internet advertising. So it's not clear how much that's actually going to capture. The second thing it does, and this is, I think, going to be the subject of much of our conversation today, is that it creates a new public file requirement for large online platforms with more than 50 million unique visitors. And they need to now would need to create these sort of online public files that contain a variety of information about requests to purchase ads, both dealing with candidates and issue advertisements. And the language is modeled on the Communications Act and the public file requirements for broadcasters, as well as a copy of the ad. And the reason for this provision, I would say, is there are several. One is that the platforms have access to certain information that the advertiser is likely not going to have as much access to. But then the other is that obviously if you're Vlad the Russian troll sitting in St. Petersburg, you're not probably going to file your electioneering communication report on the FEC's deadline. Alan works a lot with the FEC. I don't think American domestic political actors are that afraid of them. I certainly don't think your average troll in St. Petersburg is going to be very afraid. So this is, in some sense, an effort to extend regulation towards the entities that are, really the most susceptible to regulation. Let's be honest. In addition, the Honest Ad Act requires not only platforms, but also broadcasters and others to use reasonable efforts to avoid publishing illegal foreign political advertising that's barred by the Federal Election Campaign Act. And then it does a variety of things to strengthen the sort of disclaimer and disclosure requirements, which the FEC, where I used to work, has done its best to gut. And it doesn't do enough there, but it does some. So the Brennan Center strongly supports the Honest Ads Act, which doesn't mean we think it's perfect. We've publicly suggested some revisions. One of them is instead of putting the onus on platforms to create public files, we think probably ultimately there should be some sort of central database We also think, and this may be a point of some agreement on this panel, that you need to flesh out what it means to take reasonable efforts to prevent social media advertising, illegal social media advertising by foreign actors. Oh, that's my timer, so I'll wrap up. Then we also think that in terms of issue advertising, some and others, Nate personally among others have made this argument, some different methodology needs to be used to, or some methodology needs to be used to figure out what sort of issue advertising is actually covered by these public file requirements. So in 30 seconds,
You can have more than 30 seconds.
what?
You can have more than 30 seconds.
Well, I'll take a minute, but I don't want to, because this isn't the interesting part of the discussion necessarily. So a number of states or several states have created analogs to the Honest Ads Act. Obviously, we're going to talk about the Maryland law that was one analog that was sort of a weak, distorted version of the Honest Ads Act. I happen to think it was constitutional. Nevertheless, would I have argued that it reflected the best policy choices? Probably not. It had a much lower threshold for which platforms were going to be covered, and it also had a provision that would essentially create a sort of checkoff box where the advertiser themselves would be able to say whether or not the ad was a covered political ad, and if it wasn't, the platform didn't need to do anything, which actually from a policy perspective, from where I'm coming from, is probably not the best approach, and it also created a little bit of a superfluity problem. Washington State, their campaign finance regulator has actually interpreted a long-standing public file requirement for sellers of political advertising to impose a weaker version of the honest ads regime on some large platforms. California has also created a regime that's also weaker, although they're looking at expanding it. And then New York actually imposes much less obligations on the platforms, but does have sort of special disclosure requirements for online advertisers. And the platforms, of course, themselves are also engaging in self-regulation, setting up databases, in some cases limiting targeting, trying to look like good boys and girls, since they know that the spotlight is on them. So again, I'm going to wrap up by just saying that I do think that, I've tried in my remarks to acknowledge that this is not an easy area. There are weighty issues on both sides. And I think, one of the things I'm looking forward to today is that maybe we can find some common ground in the context of things that are not very straightforward right now, where there's sort of important considerations on both sides. But I'll hand the floor back over.
And can you say a little bit more? So if the Honest Ads Act goes into law, what does it specifically require platforms that host political ads to do?
Yeah, so I mean, again, I would suspect that if once it's enacted, the Honest Ads Act would change somewhat. But in principle, anyone who wants to spend in aggregate $500 in a calendar year on an ad, the platform would need to create a public file and put a copy of the ad in a public file and certain other information, including targeting information, which is very important, and which some of the platforms are now voluntarily disclosing. And then, cost information and a variety of other, the basic things that you would need to know about the ad, including the identity of the purchaser. And it is modeled on the public file requirement that we create for broadcasters already, although obviously they're not entirely similarly situated. Different states do have different models. And I think as we're sort of learning more about how this model works, the honest ads requirements, which were crafted a couple of years ago, might need to evolve. For instance, it's probably important, particularly if you do put this onus on the platforms, to ask them to include information about the number of impressions for an ad. Because really what both researchers, law enforcement, and others are interested in is how many people are viewing it and what's the impact. And that's something that they actually are able to call up pretty easily. But it basically creates a simulacrum of the public file requirement that the FCC has long required from other ad sellers.
All right, thank you. So I'm, before we sort of get into our general discussion, I'm going to walk a little bit through the Washington Post v. Mcmanis case, which involved, as Dan said, Maryland's version of such a law, and is the only sort of litigated case involving these type of regulations. So broadly speaking, the laws in this area kind of have two threshold choices. The first choice is who are they regulating, which in practical terms cashes out to where do they set their threshold in terms of monthly unique users if we're talking about an online space. So the Honest Ads Act sets it very high and is going to capture certainly Google and Facebook and maybe other very large media platforms, but not sort of the mom and pop smaller newspapers. The Maryland law was different in that it was set very low. It was at 100,000 monthly uniques, which sounds like a big number, but in practical terms, is going to capture most publications that are beyond college and high school newspapers. That's sort of the one choice. The other choice is sort of what are you going to require the platform to do? And there's sort of two areas there. One is sort of disclosure area. So what the Maryland law did is it said that in addition to the standard disclosures that will typically have to be on the face of an ad, this ad was paid for by so-and-so, the newspapers or the websites that host these ads will have to separately publish somewhere on their websites information about who purchased the ad, how much was spent, where it was targeted, et cetera, et cetera. So that's sort of the disclosure requirement. And the other requirement is a record-keeping requirement. I think is similar to the public file concept you were talking about, where you have to compile various information. And under the Maryland regime, it had to be made available to the state upon request, but otherwise you just sort of compile it and keep it. So those are—
Much less of it was publicly available under Maryland and much more of it was just sort of held.
Right. So those are sort of the areas. And I would say, it's fair to say that the Maryland law was on the extreme end. So in the Mcmanis litigation, on both those poles. So for instance, New York has a record-keeping requirement, but not a disclosure requirement. Same with California. So in the Mcmanis litigation, we brought a legal challenge to Maryland's law on behalf of a coalition of newspapers ranging from the Washington Post to quite small Maryland newspapers, but all were large enough to be regulated by the act. We brought the challenge in August of 2018, a few months after the law passed, but well and ahead of the sort of 2018 political season really heating up. We immediately moved for a preliminary injunction against enforcement of the act. We brought a number of challenges, but the most significant one for these purposes, and the only one actually addressed in the litigation, was our First Amendment challenge. We also had a Section 230 challenge, a Fourth Amendment challenge, but so the heart of what ended up being litigated in the case was the First Amendment challenge. And so when we were sort of conceptualizing our case, we viewed it very much, we viewed the case very much from the vantage point of media law and not election law. And from that perspective, it sort of struck us as a somewhat straightforward and easy case, right? We argued that the law's publication requirements, the requirement that newspapers publish on their websites information about the ads they host, was unconstitutional under the compelled speech cases that were discussed in the first panel. In particular, we invoked Miami Herald Publishing v. Tornillo, a 1974 case in which the Supreme Court struck down a Florida law that mandated that if newspapers criticized a candidate for public office in editorial, they had to then give that candidate a right of reply. And what the Supreme Court said there was, we think the law is laudable. We see various ways in which it might advance political debate and discussion, but the government cannot constitutionally commandeer the pages of a newspaper toward its political ends, regardless of how laudable and noble they may be. And we argued, at least with respect to disclosure provisions, that sort of this case was more or less on all fours with the Miami Herald case. The state of Maryland had goals that they wanted to achieve, and they were sort of commandeering the website pages of the newspapers to do so, which was not allowed under that area of law. We also argued that the law's record-keeping provisions were subject to strict scrutiny under Reed versus Town of Gilbert, which was also discussed previously, and therefore, to the extent that strict scrutiny is fatal in fact, probably unconstitutional. And the basis for that argument was that the law singled out political advertising. It didn't apply to advertising for shoes, for cosmetics, et cetera, and under the framework developed in Reed, strict scrutiny applies under that context. When the state of Maryland, joined by various amici, including at the appellate level, Dan's organization, when they opposed our motion, they were sort of equally confident on their side. Their essential argument was that we were applying the wrong body of law, that this wasn't a case that should be governed by Miami v. Tornillo or the Reed decision, but was a sort of reasonably straightforward campaign finance case that should be governed under cases like Buckley v. Vallejo and Citizens United and their progeny. And those cases have generally upheld regulations on ad purchasers that require them to disclose who they are, how much they're spending, et cetera, et cetera. And those cases, instead of applying strict scrutiny, have applied sort of an intermediate form of scrutiny called exacting scrutiny. And although exacting scrutiny is not nothing, there's sort of a well-established body of law that says the kind of things these disclosure laws are trying to do, increase transparency, reduce corruption, educate voters, all of those are sufficiently important to allow these laws to pass muster under exacting scrutiny. So that sort of became the big First Amendment issue in the case. Is a type of regulation that has been repeatedly held to be constitutional when applied to ad purchasers. Does the constitutional analysis change when you shift from regulating the purchasers to regulating the platforms? The sort of smaller First Amendment issue that obviously hooks onto that one was, does this law actually do anything? Is it effective in accomplishing its goals? And we argued that it was over-inclusive to the extent that it was regulating small platforms and not just focusing on the Facebooks and the Googles of the world. And we also argue, and I think Dan sort of alluded to this in his remarks, that it was under-inclusive, that the real problem of 2016 wasn't paid political advertisements, it was unpaid political speech. It was the troll in Russia or the troll in his mother's basement in Maryland who was pretending to be someone he wasn't and sort of criticizing Hillary Clinton about voting for the crime bill or something like that. And that wasn't regulated by the law. So that was the terrain over which was litigated. The district court granted our preliminary injunction on First Amendment grounds. It sided with us on sort of the threshold First Amendment issue and held that the law should be evaluated under strict scrutiny. And the reasoning was that the sort of exception to applying strict scrutiny to content-based regulations that was articulated in Buckley and Citizens United is a narrow exception, sort of special to the case of political ad purchasers. What this Maryland law was an extension. It was something new and was regulating a different set of speakers. And the court was unwilling to extend anything less, or unwilling to extend that narrow exception and apply anything less than strict scrutiny. The court also held that it wouldn't survive exacting scrutiny either. The case was then appealed to the Fourth Circuit. In December 2019, the Fourth Circuit affirmed the preliminary injunction in a unanimous decision authored by Judge Wilkinson. Judge Wilkinson reserved on the question of strict scrutiny versus exacting scrutiny. He said, I don't need to decide that issue here. But nonetheless, his analysis sort of very much bought into the premise that we had advanced in our briefing, which was there's something different when these laws regulate platforms as opposed to political ad purchasers. Sort of part of what the judge did is say, well, there's something unseemly about governments interfering with newspapers. That makes me nervous. But the sort of more substantive argument was to pick up on something we had argued in our briefing, which is that, from the standpoint of regulation, the difference between regulating political advertisers and regulating platforms is essentially one of motivation. Political advertisers are highly motivated speakers. You can sort of burden them with disclosure and record-keeping obligations, and you're unlikely to chill their speech. Their speech is sort of hearty. But the same doesn't apply to the platforms, right? Most newspapers will have policies about what ads they'll accept and what ads they won't accept. But within that broad area, they're indifferent as to whether they're advertising for gum or for for gum or for shoes or political candidates. And that if you impose regulation just on one category of ads, you're going to discourage the platforms from running those kind of ads. And in fact, in Maryland, sort of Google, in response to the law, stopped running political advertisements in Maryland. So the Fourth Circuit held that essentially the law puts a thumb on the scale against one particular type of ad, a very important type of ad because it involves political speech. And that made the First Amendment burden so profound that whatever benefits the law could achieve weren't worth the cost of doing so, and so affirmed. And then just to wrap up the story of the case, recently the district court converted the preliminary injunction into a permanent injunction based on a stipulation of the parties. And so Mcmanis is the one sort of case we have addressing these. So I want to turn to the panel finally. Rick, in conversations, you have intimated or suggested that you think the result reached by the Fourth Circuit was correct. But do you buy into this distinction between regulating political ad purchasers and regulating platforms? Does that make a difference from a First Amendment perspective?
Well, let me start off by actually trying to situate the moment we're in a little bit in the history of campaign finance regulation and then get to the specific question. So the last time we had national legislation on campaign finance laws was the McCain-Feingold Act in the early 2000s. And the paradigm that that act was focused on was the broadcast television ad. These were extremely expensive. They reached large audiences, largely captive audiences. And that's sort of the universe in which our existing laws were constructed. What that law did was a variety of things, but for example, it banned corporations and unions from running ads 60 days before a general election that mentioned a federal candidate targeted to the electorate for that office, and imposed various disclosure requirements. Now, we have not had major federal regulation. We have not had any in terms of legislation, and the FEC has not been a regulatory agency in this area, has not done very much, particularly with respect to the rise of online political ads. What's happened since McCain-Feingold and all the intervening years is there's been a tremendous growth, really an explosive growth, even as recently as 2016, in the amount of money that campaigns and various groups are spending on online political ads. We're seeing a migration of spending from television, which fewer people now use as their major source of entertainment and news, to online digital political advertising. So an explosive rise, and we expect that to continue in 2020 and probably to continue after. Secondly, this rise of digital political ads has a different structure than the traditional TV broadcast ad and raises distinct kinds of issues in several important respects. One is anonymity is much easier to achieve with online political ads. Second, there's even invisibility of the ads themselves, where it's much harder to actually be aware of them, because especially as these ads have moved towards what's called micro-targeting, where campaigns or other groups identify the particular people they want to receive a particular ad. Those ads may be to a small audience, even if they're effective, they disappear quickly, they're fleeting, and so that poses a different kind of challenge as well to the traditional broadcast ad. And the third thing, of course, which we became aware of with the 2016 election, is much greater risk of foreign meddling or manipulation, attempts to influence, or just so, distrust of the political process and the electoral process. And that's not something that we had with the traditional TV broadcast ads. Now, the traditional justifications for regulating in this area, primarily through disclosure, has been first an informational interest. Voters have a legitimate interest, and states can regulate to realize this interest in knowing who's behind ads, what's the source of this, what might their interests be, how much money is being spent. That's an informational interest. The second interest that the courts have identified is an anti-corruption interest. So if we're worried about certain spenders being able to influence office holders, candidates and then office holders, through political advertising, there can be a genuine anti-corruption interest that justifies these kinds of regulations. And then the third, which is somewhat newer after 2016, is the interest in avoiding foreign spending, trying to influence American elections. Okay, so that's kind of the situation in which all this is now arising and coming to a head. And particularly since 2016, as Dan mentioned, there have been efforts in the states and now in Congress to try to bring the regulatory regime into the online world. But there are a lot of complexities that poses. There are no real issues, I think, in requiring those who buy the ads to be subject to the same disclosure and disclaimer requirements that apply to ad purchasers on television. And Maryland did do that in your case, and that wasn't challenged in the litigation, and the court said nothing about that. The distinct issue, as you've identified, is for the first time we're seeing, or not the first time, that's not exactly right, but there's an effort to regulate the platforms themselves. Okay, it's true that the broadcast networks have had certain regulations imposed on them historically with respect to political ads and disclosure information. But the platforms are now facing this for the first time. And the question is, how does the First Amendment and the legitimate regulatory interests apply to kind of this whole regime? Now, I think the Maryland law was a particularly badly drafted law for a variety of reasons. For one thing, if you write a law that ends up with the Washington Post as the lead plaintiff against you, arguing that the First Amendment stands in the way of the obligations you're seeking to impose on the Washington Post online, you're not in a good place to start with. That's not the plaintiff you would like to be litigating against you. You prefer it to be Facebook or Twitter. And the Maryland law, as you mentioned, applied to virtually all online platforms and websites. Sensible regulation in this area, because we are dealing with complicated First Amendment interests. You're talking about regulating political speech, which is the absolute core of the First Amendment. You're talking about what some might view as compelling platforms to speak in certain ways, as the first panel discussed. The courts are getting more aggressive about compelled speech doctrines. And so the regulations and the laws have to be drafted with considerably more sensitivity to these issues than the Maryland law. I do not read the Fourth Circuit decision, which is the first appellate court decision we've had on any of these issues, so it's very important. I do not read it as holding that it is per se unconstitutional under the First Amendment to impose certain kinds of obligations on platforms. The court certainly goes out of its way to talk about the fact that the Maryland law applied to very small online websites, as well as to media like the Washington Post, not the platforms. My own view would be that the sensible way to begin drawing laws here, and this is part of what the Honest Ads Act does, which is, as you say, has passed the House and has several sponsors in the Senate, is to target the largest platforms. That's what we're fundamentally concerned with. And Facebook, Twitter, Google, Instagram, which is part of Facebook, of course, perhaps YouTube. But don't go beyond that at the first stage of trying to figure out how best to bring the regulatory regime into the modern digital era. I think once you do that, the online platforms begin to resemble, in some ways, the traditional broadcast television networks. Greater regulation of the broadcast networks has historically been justified and upheld under the First Amendment based on the idea that there's a scarcity of spectrum for that. And so they have distinct obligations. They are, in some sense, artificial monopolies created by the state, which gives them these licenses. You can certainly view the major platforms as natural monopolies. They've arisen because of the economies of scale, network effects, first mover advantages. But I think the analogy to the traditional broadcast networks becomes stronger when the laws are limited to the really most dominant, largest scale platforms. So the way I read the Fourth Circuit decision, it can be read differently, but the way I read it, it still leaves open regulation, appropriate regulation of the dominant platforms. Now, I think, and I'll stop with this point, I think that what the court in the Fourth Circuit was concerned with, and all courts will be concerned with, is actually not so much any compelled speech, although they talk about that. the platforms having to publish information about the ads that you guys discussed already. I think what the main worry really is ensuring that the burdens these laws impose do not significantly chill core political speech. And to me, that was the driving concern. Not so much that the platforms are being compelled to provide basic information about who's running these ads, but that if you make it costly through regulation to run these ads or host these ads, platforms may decide they're just not going to be in the business at all of being willing to host these political ads. In fact, Google said in Maryland it was going to stop running political ads in Maryland once the law was passed. And the courts are concerned that over-regulation, a regulation that's not carefully tailored to these three purposes I mentioned at the outset, will be burdensome and will lead platforms to run other kinds of paid ads, but not paid political ads, because the latter is much more costly. And I think that's what we need to focus on. That's what legislators need to focus on. I think that's what courts are going to focus on. How burdensome are these regulations? How closely tied are they to these three legitimate purposes for regulating? Are they narrow enough? And I think that's really the question with the Honest Ads Act and this whole cluster of issues.
So, Alan, you represent principals rather than clients like me. So if you know, the Honest Ads is passed and it's structured in a way that it does what Rick was suggesting, that really is highly targeted on the platforms, would you be satisfied from a constitutional perspective?
I don't know. You know, I think there's not a lot to say after those very magisterial instructions. But I think the facts in this case really matter. And I think one of the things that's getting lost here is just how difficult it can be for even the large platforms to function in this area. I mean, you see that we've talked about how Google exited the marketplace in Maryland. You know, Facebook attempted to exit the marketplace in Washington State in response to a similar kind of law, and wasn't able to do so, and is now, you know, looking at an enforcement action by the Attorney General of Washington as a result. So my sense is that, in some sense, here's the key question: if you or I were to go into court with a client, and as has already been said, it'd be worse for the government if it was you and your client.
Particularly me. It'd be very bad if it was me.
Principally you, yeah, that's true. But if you have the sort of affidavit that was present in your case, where the plaintiff says, no, as a result of this, we're going to be forced to exit the market, or it's just not going to be profitable or interesting for us to, you know, convey or provide this service, that I think could be determinative in a lot of ways. I think, you know, you're much more likely to get strict scrutiny, but even under exacting scrutiny, you know, I think it really depends on how the government justifies this. I couldn't help noticing the move from, you know, Dan's invocation of, you know, the role of issue speech and foreign meddling in elections to, you know, Rick's, I think, much more traditional explanation of what the governmental interests are. And I think one of the problems in your case was that Maryland really just could not show any effective foreign policy or you know, end here, whereas they may have been on stronger ground if they had stuck to a traditional campaign finance framework. And Honest Ads Act, frankly, it doesn't do a good job deciding which side of the line is going to be on there.
Dan, I see your hand raised, but also just in addition to what you were going to say, does federalizing the law as the Honest Ads Act does that address the exit problem that Alan and Rick have both sort of flagged?
Well, that's actually a really interesting point, and it's one dimension of the Mcmanis litigation that we haven't talked about. Is there a court is also likely to ask, you know, Congress may be differently situated than a state legislature. You know, Congress actually has assumed quasi-plenary authority over it's actually the only aspect of the Federal Election Campaign Act that applies to state elections and local elections too, which is the prohibition on foreign nationals. So one of the questions I think also is the fit between the interests that the policymakers have, and I think the states would do well, I think, when they pass these laws to ground them in the traditional principles Rick articulated and the concern. I do think they have a legitimate interest in preventing, sort of defending national sovereignty. They are part of our federal system, but I think being in touch with both of those principles, and you picked up a little bit that Maryland shifted somewhat during the course of that litigation. I will say one just interesting thing in response. I agree with a lot of what Rick said. I did think the Maryland law was constitutional. I testified in favor of it, an earlier version of it. And one thing that's interesting is a number of the provisions that made the law a bit illogical, shall we say, sort of came in after that. I'm not trying to.
Or to blame.
Pardon?
You were not to blame then, is what you're telling me.
No, I know this sounds like CYA a little bit, but like, we've all, this has been a learning process, but the law was altered in certain ways. And actually Facebook, ironically, you say, who would you like to have your plaintiff? Facebook called it a model for the nation when the final law that I think that they had some role in crafting. So it's an interesting political dynamic that's playing out around these laws. I mean, I think in some sense, Facebook's interests might be to have a law that sweeps in a lot of different platforms and has a very low and is not necessarily focused just on the very largest. But when you accede to that too much, you might create some constitutional peril for yourself, is one of the lessons from this case. Like Rick, I do not believe that it forecloses certainly the Honest Ads Act or other state regulation. And I disagreed with aspects of the Mcmanis ruling. But I think that, there's so very much an iterative process going on.
I think there's another angle there too, which is that, you're going to start with the larger platforms. And I think there's a lot of sensible reasons for doing that. But I think we should have our eyes open to the fact that you're going to end up in one of two situations, assuming that, the law is passed and upheld. Either it's going to be effective in deterring this sort of activity on large platforms, in which case that activity is going to move to smaller platforms, and we're going to be having this conversation about smaller platforms, or it's going to be ineffective in deterring activity on larger platforms, and then you can really doubt whether the entire project was constitutional.
When you say deterring activity, you mean deterring illegal foreign interference? Yeah,
that's what I principally have in mind.
Because I don't think the goal is to deter people from engaging in that.
I'm pleased to hear that.
I'm glad we can agree.
So there was allusion earlier to various efforts at self-regulation. So Twitter, as we know, is no longer running political ads. Facebook has endeavored in various ways to sort of create its own archives so they can deal with the problem I think Rick alluded to, which is that with micro-targeting, these ads are taking place under the radar, so to speak. The public doesn't know who's running them because they're so targeted. You as an opponent, you may not know what ads your opponent's running. And Twitter, I think, Google, I think, has, decided to stop doing micro-targeting with respect to political ads. So I guess two questions. I guess Rick and Dan, sort of why, to the extent that why are the companies sort of doing this? Why are they sort of voluntarily self-regulating in this area? And is it a good thing if part of the self-regulation has involved Twitter just not running political ads at all?
Yeah, so I think this is a very large issue in trying to come to terms with the online world and whether legislation from the state is needed and will be well adapted, or whether self-regulation by the platforms is more appropriate. So the argument against legislation is this world changes so rapidly. The actors who are regulated have all sorts of ways to adapt. And it's very hard for legislation to keep up with that. It's very unlikely, in my view, that the legislative process would be able to keep up with those kinds of rapid changes. It's possible a regulatory agency could move more quickly than Congress, but that hasn't been the case with the FEC. And so it's unclear how well a state or federal regulatory regime can really keep up with the problem, and the platforms can adapt much more quickly. They see what's going on. They have all sorts of ways of detecting, bots and various other forms of new activities by foreign actors. And as you say, since 2016, major platforms have all adopted a number of changes in respect to what was disclosed of the Russian efforts to interfere. Facebook in particular, I think, has done a fair number of things that the Honest Ads Act would actually require. And of course, we know, by the way, in all regulated industries, the large actors always prefer, if there's regulation, that it apply to everybody. They often are actually proponents of regulation because they can absorb the cost much more easily than smaller actors. It's a competitive advantage for them in some sense. So I don't put much stock in Facebook having adopted the sweeping policies of the Maryland law. But I think there's a real question of whether the effective regulation is going to come through the self-regulation by the platforms. Now, of course, the downside to that is there's a lot of distrust of the platforms. The minute they start regulating, there can be concerns about whether they're applying regulations in an even-handed way. National legislation, it must take into account a lot more interests. How much do we want to rely on Mark Zuckerberg or Jack Dorsey to be making these decisions? But I think this is a real issue about whether self-regulation is the only way to actually keep getting out in front of this problem, and whether it might be more effective or not.
So Dan, where's the impetus for self-regulation coming from? And from the standpoint of your organization, what is your view about it?
Well, I want to join a lot of what Rick just said. I mean, I think that, and actually, I don't see Facebook, for instance, saying that the Maryland law is a model for the nation is necessarily a sign of public spiritedness either. Like, there's a sort of a complex dance going on, right? Which is the push for more government regulation leads the sort of biggest industry players to say, well, we'll do some self-regulation and back and forth. I'm not sure what Facebook necessarily would have done if it hadn't been that the Honest Ads Act was out there. They kind of modeled what they were doing on the Honest Ads Act. And in fact, Canada and other countries are imposing very similar requirements. So they are already legally obligated to do a number of these things in various other places where they operate around the world. But from our perspective, of course, there's a role for self-regulation. There's a role for them to partner with the government. What I always do say to libertarian friends also is that, I mean, in some sense, if you are worried that the platforms left to their own devices are just going to try to avoid risk, right, and stay out, I could see that in a world chilling speech. Like, so there's a way that you design regulation to balance the need for disclosure, the need for various safeguards to protect the integrity of our electoral process, but also preserve the ability to engage in online speech. And in fact, in the unpaid realm, where you're starting to see calls to like ban lying and stuff, I think that's a very real thing. Like, I think, wonder whether you really just want the platforms to make those decisions on their own. But I think Rick also pointed to a really interesting tension, which is in some ways, because of the dynamic nature of this field, it's tempting to just say, let's create a broad legal rule, use reasonable efforts to keep illegal foreign spending off your platform, and then leave it to them to develop, right? But that obviously runs into problems which we've seen at the FEC, where I used to work, which is that if the rule is too broad, you can end up being able to sort of drive a truck through it and it's not effective. But then you are faced with the other extreme, which is that if you develop very specific requirements, then they rapidly become out of date. And even the Honest Ads Act, right? It doesn't include the current draft, and the drafts that have been passed doesn't include, the number of impressions. And we now know, after we've studied this for a few years, that actually one of the really interesting data points you need to know what the actual sort of saturation of an ad is. And I don't have an easy answer to that. Like, I think regulating in this space is very hard precisely because of that tension between the need to accommodate rapid change and the need to set some meaningful standard. It would be nice, and this is actually another issue I work on, if we had a functional regulator in the FEC. We do not. And that actually is a major impediment for a lot of this stuff, including how do you actually come up with a workable framework for designing what an issue of national legislative importance is. Because really, in some sense, the FEC could potentially play a role if it were actually sort of compos mentis, which it's not right now.
Alan, do you have thoughts about the self-regulation issue?
A few. I think there's another argument other than can we get the regulation right, and I think that's important, and the usual caveats apply. But if we're already in a situation where we're flirting with the shutdown of particular types of speech by private actors, the need to sort of, for any quantum of disclosure you're going to get out of a voluntary system, if you add on the facts of potential legal liability, either regulatory or criminal, or however we end up structuring this, I think any in-house attorney is going to tell you you're going to end up with a more costly quantum of information that's conveyed. And a lot of my concern in this area is less on the sort of back end of how you design this, and more on the front end of what gets captured. And our history of regulation in this area is not a happy one, in the sense that, not to retell the history, but, back in the day when the Supreme Court decided the Buckley versus Vallejo decision, there was a real concern about unconstitutional vagueness. And so they imposed this magic words test to determine what speech was going to be regulated and not. And we've really, I think, struggled as, experts in this area, looking at edge cases to decide what's in and what's out. A lot of the complaints at the FEC come out of these sort of fringe cases about what's being regulated and what isn't. You can kind of do that if you're dealing with limited spectrum. You can kind of do that if you're the speaker and you've got a human being somewhere in the process. But I think we need to remember that, this is an area where this is all going to be done by algorithm. This is all going to be done by computers. We're going to have very deep problems of over or under capture. And adding the possibility of governmental sanctions onto that already complex and messy environment, I think it's just another factor that's going to go into the chill bucket.
I want to point out also for the audience, how hard some of these problems are. So we're talking about two different things which are kind of brought together with the Honest Ads Act and these other state laws. One is dealing with foreign intervention, and the other is updating the regulatory regime that already applied to broadcast, cable and the like, to the online world. And those are two different projects. One of my complaints actually with the Honest Ads Act is that it's not nearly aggressive enough about dealing with the foreign interference issue, because I think it's talked about as motivated by that, but I think the second consideration may be actually driving the sponsors more. So all the Honest Ads Act does is tell the platforms they have to make reasonable efforts to make sure that the money, the ad is not being bought by a foreign individual or entity. I think if we focus much more on that problem, legislation targeted to that problem is going to find much greater receptivity in the courts, because this is a core policy interest. As Dan said, Congress has banned foreign interference at all levels of the election process, not just for the national elections, understandably. And so I would like to see more effort targeted to that. But here are a couple of the things that make this so difficult. All this legislation we're talking about is dealing only with paid advertisement online. Why does it limit it to paid advertisement? Because it becomes an incredible kind of First Amendment and policy kind of quagmire if you're going to start trying to regulate communication on the internet that is not paid advertisement, but just communication. But at the same time, these foreign entities or other political actors don't really need to spend money to use the platforms to try to distort and manipulate and interfere in the election. And so it's understandable the laws are limited to paid ads because you need that to make it plausible even for some form of regulation. It can't apply to everything that could affect politics, but it's not clear how much you're really getting at least the foreign interference issue when you're limited to paid advertisements. That's one big problem. The second big problem, which we alluded to earlier, but I want to kind of, drive this point home. Our campaign finance laws up till now have targeted stuff only in the domain of what's called election-related matter. And that, and in the McCain-Feingold law, that means ads that mention a candidate 60 days before the general election. What we learned in 2016 is a lot of the Russian spending was not on those kinds of ads. It was about issues, gun control, race relations. No candidates are mentioned. They're not saying we want you to elect A or defeat B. They're sowing conflict around politically charged issues. And so the Honest Ads Act, in response to that, has a very sweeping definition of what's going to be covered that is well beyond anything that our prior laws have covered, but for understandable impulses, which is the law applies to any paid ads that not just mention a candidate, but even if they don't mention a candidate, are on issues of national legislative importance. Now, what does that mean? How do we define what those issues are? Who is going to define those issues? Do the platforms have to define it for themselves? Are we going to have the FEC in advance of an election sort of put out a list of the 25 looming issues of national legislative importance in this election cycle? That's a very complicated set of issues. We are driven there because of what the Russians did in 2016, and that is a real concern. But it shows you how expansive this regime has to be within the limited domain of paid ads. And so I just say all that to try to illustrate for people just how complicated this problem is, how to deal with online political material, whether paid or not, to address both the risk that big money will corrupt office holders, that voters need information, and that we want to stop foreign interference. But in this new world of online platforms and the like, the problems which were hard enough when we were just dealing with the old world of the broadcast TV ad are so much more complicated. As I say, both as a matter of policy and as a matter of First Amendment law. And we're just at the first stages of all this.
Yeah.
I just want to respond a little bit to a couple of the things that were said, and then I think Alan looks like you want to get into, but I'll try to be quick. I'm sympathetic to all of those concerns, actually, and that's why I don't think this is a straightforward area, although I do think a lot of these problems are soluble. I would note that the language, issues of national legislative importance, is longstanding and has been applied by broadcasters for decades. Now, how they are applying it and whether we would be satisfied with that is a different question, but it's not like this is a completely novel concept that has never entered our consciousness before. More broadly, I do think that you need to remember the Honest Ads Act is not intended as a complete solution to all of this. It is part of a package of other reforms that are a little bit beyond the scope of this panel, but both in the landmark HR 1 bill that the House passed at the beginning of, or in March 2019, which the Brennan Center worked a lot on. There were a number of other reforms, and then they passed a sort of more foreign interference focused package in September called the SHIELD Act that had other measures. So I think the Honest Ads Act has never been sold as a complete solution to any of this. I think it's important, and as I said at the outset, I do think that paid advertising plays a role. And I think that it intersects with the unpaid communications, and that the government doesn't have to, when it intervenes, try to solve the entire problem if it can solve a part. And in some ways, paid ads might be a little bit the low-hanging fruit. And you have to be honest that it's not going to solve the entire problem, but that doesn't mean that it can't help and that it doesn't serve a legitimate purpose. So I have other things I would say, but I wanted, Alan, you wanted to get in, so
Thanks. So I guess it's because I'm the First Amendment litigator on this. There's a constitutional dimension here too, which is that, going all the way back to the moment that the Supreme Court carved out this exception for a particular type of content-based speech regulation, campaign finance law, the central project has been to try to keep that directed, as Paul and Rick have said, at elections. And to specifically protect the discussion of issues from those burdens. And it's true the courts have allowed incremental regulation in that area, but generally on the basis of very significant factual records. The FEC, the McConnell versus FEC case, I think succeeded in moving that goalpost slightly because people went to court and built a 100,000-page record of exactly why this incremental step was so important. And I think until we decide whether the regulatory goal here is just to import that online, or if we're talking about a national security package, it's going to be very hard to assemble that kind of intellectual firepower. And I think it's important to keep in mind how much of a doctrinal shift we're talking about here.
Alan, I'm just going to stop you right there. If you and I can agree that maybe in these cases, generally, courts should be allowed to assemble voluminous records as they did in McConnell, as they were not allowed to do in Citizens United or in McCutcheon or in any of the other Supreme Court's campaign finance cases, I'd be happy to join you in that project, because I think that we have advocated from the outset, these are not easy cases, and that's why the courts do need to have, complete records in front of them before they solve them. Now, this is getting into a broader tension. I don't think campaign finance is an easy field, and I think it intersects with a lot of other complicated issues. I think Maryland could have built a better record in its defense of its law, and I hope other jurisdictions will do that. One of the things we're running into is that is not how the courts actually in the campaign finance space, or increasingly in the rest of the First Amendment space, really approach these cases. It's been a very ideological, very kind of first principles approach. I think that actually, we maybe agree on this, that in this particular sphere, more of an emphasis on record building, more in the emphasis of really trying to ground policies in sophisticated sort of determinations of what are the actual facts, what are we trying to accomplish here, is great. And I would love to see that. I hope the courts will allow that, because they haven't in other spheres. In this.
To pick up on something Rick was saying previously, so one of the arguments we made in the Mcmanis case was that, the definition of what kind of speech was covered by, or what kind of ads were covered by the regulation was unconstitutionally vague because it wasn't tied to candidates. But that hooks up to an interesting, connecting that to the foreign interference issue. As Dan sort of noted earlier, sort of one of the unique features of the Mcmanis case was the way it was structured. The ad purchaser would sort of identify the ad being purchased as subject to the act. I think you check a box or do something equivalent. And we had fun with that in litigation because we, as Dan pointed out, this sort of, hypothetical nefarious Russian interferer is not going to be scrupulous about filling out forms. But there's a real reason the law was structured that way, which is that if you place the onus on the platforms to go through their whole ad catalog and say, oh, this one's covered, this one isn't covered, then the law starts to become quite burdensome potentially. So, do you think, there's a way out of that, right? Because either if the onus on identifying which type of ad is subject to the act falls on the purchaser, then litigants like myself have an argument that's just superfluous. But if it doesn't do that, then it starts becoming, quite burdensome. Do you think there's any sort of way out of that trap?
So this problem has bedeviled campaign finance regulation, even in the old world. And what's the threshold for determining, what material is covered or should be covered? The more you make the test objective based on a couple of factors, the clearer the line is, the easier it is to administer. And that's why in the McCain-Feingold law, they said, mention a candidate 60 days before the general election or 30 days before a primary, that's covered. That's a pretty simple, straightforward, easy to apply rule. The problem is once you try to go beyond that and deal with what the Russian interference in 2016 included, which is trying to interfere by manipulating perceptions about issues like gun control or race relations, how can you devise a clear threshold rule as to what's covered or not?
Sorry to interrupt. I'm being reminded that I have to read out the CLE code, which I forgot to do at the appointment.
Oh, that's the most important part.
The most. Literally, I only had one job. The code is IDSK10. That is IDSK10. Thank you very much. All right, Rick, continue.
Well, so in the Maryland case, as you say, the law put the burden on the ad buyer to say to the platforms, hey, this is a political ad, we're covered. And of course, particularly if you're dealing with the issue of foreign manipulation, it's hard to believe that foreign actors who are trying to make themselves anonymous to begin with are going to comply with that. So putting the burden on the ad purchaser, at least for the foreign interference issue, it isn't gonna work. But that then puts the burden either on a regulatory entity like the FEC to define clearly what is a political ad, including issues of national importance, or puts the burden on the platforms to do that. And as you say, that really does up the burden significantly on the platforms. Now, Twitter, by the way, this is interesting. Twitter has banned paid political ads, but they're not even relieved of this problem because they have to decide what is a political ad.
Mm-hmm.
So they actually face, even if the platforms say, okay, we're not going to take paid political ads, period, they're still in the position of having to make that threshold determination. And it's an inescapable and extremely difficult problem that, as I say, has bedeviled these laws actually since the 1970s when we had our first modern wave of national campaign finance law preceding the campaign finance law.
Dan, I should let you talk. I want to address some of the questions, if we have time, that have been submitted.
Sure, well, I'll keep it quick. One solution, obviously, and one that we advocate is the one Rick proposed, which is, start with the largest platforms. I mean, I think that there are other problems with sort of open-ended best efforts, reasonable efforts, standards, but I do think that if you're regulating Facebook, Twitter, Instagram, it's less of it's harder, it's not as credible to say, oh my God, this is a huge burden, particularly since they're already doing it right now, purporting to do it. The only other thing is this is where this debate intersects with a much bigger one that we're having, and that's raised by the sort of confrontation between the president and Twitter, which is the same exact issues come up when you're starting to talk about hate speech, when you're talking about fact checking, so either if you want to say these problems are intractable, sorry, we can't do anything, you're going to have to say it in a lot of different areas, not just this one. Or you're going to have to plunge in, you're going to have to try to set some standards. But I think that's what, vast parts of this field are wrestling with right now.
So there's a question, I'll stick with you, Dan. You mentioned that some displeasure with the record that was built in Maryland. The questioner has asked whether there's social science evidence of the harms of sort of online paid political speech, and whether that was part of the record in Mcmanis.
I don't think I don't have the record in front of me, but I'm not aware that it was. I think that there's a lot of evidence about the saturation of these ads and how they're being exposed and how the tactics. I think that there's sort of only now emerging social science evidence about what sort of subjective impact the ads have, and I think it's conflicting. And the case for disclosure, I think has never really, more broadly, there is a fair amount of social science evidence that shows political ads and also knowing who is behind them does have some impact. But I think that, this is also, it's not just about social science. Also, there's received wisdom by the courts have recognized for almost a century that, sunlight is the best disinfectant and that it is important to know who's trying to influence you. But Maryland could have done better on that front and made that point harder. And I think that is going to be one, frankly, I'm just going to be honest, like one challenge if for people like me who are advocating for these laws is really urging that kind of stronger, more thorough case to be made.
I think that's the easiest part, though. I mean, because that sort of evidence would go to the weight of the government's interest, which is, I think, the part of this where there isn't a lot of disagreement. The problem is going to be proving tailoring and effectiveness.
Fair enough. And on that note, we have reached the end of our time, but I want to thank our panelists very much. This was an excellent discussion. I enjoyed it and learned a lot. So thank you very much.
Thanks for having us.
And I want to thank you all as well, and tell you how valuable it was as a discussion for you and for our attendees. We're going to take a break for lunch and return at 12:30, please. At least I hope we'll see all of you, where we're going to have someone from the European perspective give us a heads up on some issues that we may not be paying attention to, but that Remy thinks we should be paying attention to as lawyers and scholars who care about the issues we're discussing today. And then we'll go directly into the rest of our afternoon program. The session about algorithms meeting the First Amendment and the state ability to regulate what you call things. I hope to see you all back here at 12:30. Again, to this panel, thank you.
Thank you.
Thank you.